Rachel,
Whatever you're ready.
It is, maybe.
I haven't seen Kevin.
Hot minute. But I don't know if there's really ever.
It's not a requirement, but it's an at-large member.
Are we making the motion again? Which is after this one.
What about Stephen?
Got it.
Okay,
Go.
right, got you.
You know what? That's something made me think about when we were kids.
Alright, you good?
Kids always had broken arms.
Let's go.
That gives you million kudos for doing so well.
All right. This meeting of the Escambia County Planning Board for November 4th, 2025 is hereby called to order with 5 members present, or 6 members present. We do have a quorum. Just a reminder to put your phones on silent or turn them off. And if you would, please stand for the Pledge of Allegiance. All right. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement. Got a motion and a second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. Rezoning meeting minutes for the previous meeting dated October 7th have been provided to the board members. Are there any additions, deletions, or corrections? If not, I'll entertain a motion to approve.
Motion.
A motion and a second. All those in favor, please signify by raising your right hand. Motion carries. The hearing package for November 4th, 2025 with finding of fact has been provided to the board members. I'll entertain a motion to accept the rezoning hearing package with findings of fact and the legal advertisement into evidence. Is there a motion?
So moved.
Second.
Second.
Got a motion and a second. All those in favor, please signify by raising your right hand. Okay, motion carries. Will the court reporter please swear in members of the staff?
I do.
Okay. The board has previously qualified staff to offer expert testimony in the area of land use and planning. Does anyone have any questions regarding their qualifications and ability to offer expert testimony? All right, seeing none. At this hearing, the planning board is acting under its authority to,
I'll make a motion to waive the reading of the rezoning criteria to expedite things today.
okay, we've got a motion. Do we have a second? We've got a second. All those in favor, please signify by raising your right hand. Okay, motion carries. Today there is one case to be heard. The rezoning application for consideration is case number Z-2025-10, which requests rezoning of 362 West Oakfield Road, 300 block West Oakfield Road, and 227 Kenmore Road from HDMU, High Density Mixed Use, District 25 dwelling units per acre, to HCLI, Heavy Commercial and Light Industrial, District 25 dwelling units per acre, as requested by Meredith Bush, agent for Roy Lister and Four Star Drywall, Inc., the owners. Members of the board, have there been any ex parte communication between you and the applicant, of the applicant's agents, attorneys, witnesses, with fellow planning board members, or anyone from the general public prior to the hearing? Have you visited the subject property? Please also disclose if you are a relative or business associate of the applicant or the applicant's agent.
No to all.
No to all.
No to all.
No to all. No to all.
No to all.
Okay, staff was notice of the hearing sent to all interested parties.
Yes, sir.
Notice of the hearing posted on the subject property.
Yes, sir.
All right. Meredith, are you okay if they go through the photography? Okay. Staff, if you'll go ahead and present those photographs and maps.
Good morning, Allison Lindsay, Development Services. This is a location map showing the location between Kenmore and Oakfield. This is the 500-foot radius map showing the property outlined in red. This is a future land use map showing mixed use urban. And this is existing future land use showing the existing uses around. This is the aerial photography of the site. This is the public hearing sign that was posted on Oakfield. This is looking onto the subject property at 362 West Oakfield. This is looking west along Oakfield. Looking east along Oakfield. This is looking south along, actually across Oakfield. This is the public hearing sign that was posted at the 300 block of West Oakfield. Looking south from the Oakfield Road property. And this is looking onto the property at the 300 block of Oakfield. This is the public hearing sign that was posted on 227 Kenmore. Looking onto the Kenmore property. This is looking north across Kenmore Road. Looking east along Kenmore from the subject property. And looking east along Oakfield. Looking west along Kenmore Road, and that's the map.
All right, thank you. Meredith, we'll have you come forward and just state your full name and address for the record. We don't have to have you sworn in unless you've got any witnesses that you'd like to have today, okay?
Meredith Bush, 314 South Balin, Suite 108, Pensacola, Florida, 32502.
All right, and have you received a copy of the rezoning hearing package with findings of fact? And do you understand that you have the burden of providing by substantial competent evidence that the proposed rezoning is consistent with the comprehensive plan, furthers goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code?
Yes.
Okay, go ahead.
Good morning, board. I appreciate, as always, the time to come before you and present. First, I'll walk through the criteria as outlined in our application. And then I'll kind of pivot and address some of the concerns raised by staff. It's rare that we don't always agree on all the criteria. I love it when I can come before you and say, you know, we're all in agreement and ask that you just adopt. As to criteria 1, consistent with the comprehensive plan, the proposed amendment is consistent with the intent and purpose of the existing future land use category, which is mixed use urban. The LDC recognizes HCLI as appropriate within MUU. This is adjacent to major transportation networks. The site sits between Pensacola Boulevard, Highway 29, and North Palafox. MUU future land use category explicitly contemplates an intense mix of residential, office, retail, and light industrial uses, and encourages infill redevelopment where the urban infrastructure already exists. Converting these underutilized MUU parcels to HCLI aligns with sustainable development objectives by locating employment-generating uses near that Palafox Boulevard and North Palafox transportation spine. The requested district implements the MUU intensity framework and advances economic development goals. As to criteria 2, consistent with zoning district provisions, the proposed amendment to HCLI is consistent with the intent and purpose of the Land Development Code. The variety and intensity of non-residential uses within the HCLI district is limited by the applicable FLU and their compatibility with surrounding uses. HCLI's stated intent is to accommodate light manufacturing, large-scale wholesale and retail, and major services in areas serviced by transportation networks. Given the parcel's MUU designation, the HCLI intensity cap, a floor area ratio up to 2.0, and the corridors network, this request fits squarely within the district's purpose and establishment provisions. If desired by the county, the applicant is amenable to reinforcing compatibility via voluntary conditions customary to HCLI, such as enhanced screening, limited access, and orienting development away from any nearby dwellings. If you'll look back at the existing use map, you'll see that the surrounding parcel is commercial, and you'll also see on the zoning map the surrounding area as HCLI. And that kind of plays into the next criteria, compatible with surroundings. The proposed amendment is compatible with the surrounding existing uses in the area. The property is already adjacent to HCLI, surrounded by HCLI, and there's HDMU zoning. Compatibility under Florida planning law does not require identical uses. It requires uses that can coexist without material diminishing each other's utility. The comprehensive plan and LDC define compatibility in terms of complementary or mitigating design, not uniformity. As a transitional use to existing HCLI in your other non-residential districts, the request formalizes a long functioning employment and service cluster. Criteria for appropriate if spot zoning. The amendment request, if granted, would not create spot zoning. The property is directly adjacent to existing HCLI and in close proximity to other properties zoned HCLI, and then appropriate with changed or changing conditions. The Oakfield Kenmore blocks have experienced incremental commercialization and light industrial activity consistent with MUU over time. This is driven by its proximity to US 29 and North Palavox and the corridor's established supply chain and service economy. Upzoning to HCLI recognizes these evolving market conditions and directs growth to a location already equipped for this sort of development. As infill on sites with existing access, the request is not premature, does not contribute to sprawl, and instead channels investment to a logical urban node while leveraging existing public capital investments. We've also submitted a compatibility analysis which meets the locational criteria. County staff in their findings point out a few things that I'd like to counter. As far as consistency with the comprehensive plan, MUU future land use category explicitly permits light industrial and employment generating uses. The staff suggestion that commercial zoning is more appropriate conflicts with the comprehensive plan's mixed use urban framework, which prioritizes compact corridor-oriented redevelopment with diverse use types, including light industrial. And I would direct you to FLU 1.5.1, encouraging redevelopment in underutilized MUU properties, and FLU 2.3, encouraging infill development in appropriate urbanized areas where infrastructure is sufficient. On criteria B, staff incorrectly construes HCLI location criteria as limiting parcels directly fronting arterials. However, the LDC allows documented compatibility as an alternative. The applicant in this case provided a full compatibility analysis which demonstrates the property's adjacency to HCLI uses and existing HCLI zoning, its location within an established service area, and again agrees to any design commitments necessary. Next, in response to staff's findings on compatibility with the surrounding uses, again, compatibility means coexistence without adverse impact, not uniformity. Staff admits HCLI zoning already exists adjacent to the site. The requested district simply formalizes an existing pattern, ensuring consistent regulation and site design control. Staff does concede that this is not spot zoning and that therefore the request is a logical extension of established industrial and commercial activity and satisfies the LDC's intent. And as far as changed or changing conditions, again, this corridor has evolved with commercial and light industrial uses over time. Escambia County's economic development framework promotes the retention and expansion of employment centers near transportation routes. The staff's own submittal of supporting evidence, although in their findings they reference the condition of the streets, County TTO reviewed the submittal and issued no objections and that there would be no negative impact, explicitly noting that any roadway issues would be addressed at the DRC stage. Over 50% of the 500-foot radius is already zoned HCLI, and transitional zoning should match the predominant budding use, not a lesser intensity placeholder. HCLI appropriately extends the existing employment corridor. So we would ask that you adopt the applicant's findings. Again, if you'll pull up the map and show the surrounding HCLI, and that this is an appropriate zoning category for this area. I'm happy to respond to any questions and address any comments of staff.
Speaker.
Board members, yes, sir. Go ahead. I was going to ask for
Meredith, I'm shocked you enjoy an argument with staff. As an attorney, I don't mind one every once in a while either. The only thing I don't mean to point you out, sir, but did you happen? Oh, you did.
I came in. I just spoke to him. I think he told me that he just wanted to sit in and listen.
Okay.
I did tell him if you want to speak, you got to sign it. So thank you, Mr. Powell.
Yeah.
I did notice that too when I came back in.
Yeah, I mean, obviously, I very well articulated arguments, but I keep seeing the single family, and this is where I think this board actually gets to utilize the gray matter between our ears, because we didn't start this county on a perfect flat plane and have everything sectioned off nicely. We run into these situations where people from the outside drive by and go, what were they thinking? Why would they ever do something this silly? But now we have single family, and what always concerns me are the people. And I mean, I feel like I guess it speaks volumes that no one's here to speak anything to some degree, but I don't know.
And I'd like to respond to that. Now, yes, you are correct. There may not be no one here to speak, but that's the job of the planning department, the development services department, and I believe that's your job as well, to look at the criteria. Because just because they may not be able to hear, many times citizens are not engaged until it directly come, things start going up. Once they start going up, believe me, we definitely get all of the phone calls from every which way. So I understand what you're saying, but Ms. Lindsay, she'll present the findings, but again, we have to look at, because I will receive the phone calls and I will get calls on once it's actually going up. So we have to, that's a good point, but I can't, and my department cannot look at because people are not here.
Are there any other questions for the applicant at this point? Yep.
I've got just a simple question. I'm slightly confused by two pictures on page 22 and page 24. Are you sure that's the applicant's? I thought that was Philium. That was because
That's the location of the sign, correct?
Philium has a gate around it. I didn't think the applicant had a gate on their premises. So just making sure it's the right pictures that we're presenting in our findings, because that right there is the Philium building.
You would know, right?
Yeah, I would. Been there many times.
It is. I know exactly what it is.
So we have our sign on the wrong parcel, and we have the wrong pictures. It looks like, because it is sitting there on, the sign is on the corner of the Philium and within the gate. To me, that's the wrong place, and I don't know if that constitutes a violation of proper notice to everybody, but that may squish this meeting today.
That's a very good point.
Yeah.
There'll be 3 parcels.
I'm gonna leave it up to you, but it's on the wrong property.
So this is. So this is Philium.
What do you think?
Where the sign is.
Oh, I think they have to be very.
This is the insurance. This is the
Gotcha. They were one block
one
off.
block off.
I didn't. I mean, I know.
Because this right here is the fence line.
Similar color. That's why I looked at
The
it.
sign's right there, and
That's definitely.
over here.
Good catch, Mr. Rushing.
Good eye, Reed.
Yeah, good eye, good catch. You paying attention?
And I do apologize. I didn't look at the pictures today, and I take full responsibility for that. When putting out the signs, Ms. Kane, she put the signs out, so we have to really. If that's an issue, I do want to be fair. I do want to correct. If that's the wish of the board to squash, we'll get with to consider. We'll bring it back at our expense. If that is this, they was so clearly identify the right parcel.
Okay.
Signs out accordingly.
We
Is that the wish of the board at this moment?
I'd love to hear from our attorney.
Yeah,
Chairman, I'd like to hear from the attorney as well.
hey look. This,
Oh, you're just
there definitely are 3 parcels involved.
If the sign was posted on the wrong property, my suggestion to the board would be to continue this and have proper notice given by having the sign posted on the correct property. I don't think we could continue if proper notice wasn't given to the public as to the proper lot.
Okay.
Sure, so without a sign posted on the correct property, there's not sufficient notice to the public. So my recommendation would be to continue this hearing to have the sign posted on the correct lots.
Okay.
And if I may, Attorney, I would like to hear from the client if she feels like that it's what if that's what's up the board.
You represent any challenge at all later on.
Of course, I agree with you. I agree with you. Thank you, Mr. Reed.
Correct, and I'm not familiar with that fence. I mean, I've visited the site and seen my own photographs, but if it's a representation that it was misposted and proper notice hasn't been given, then we would have no objection to properly notifying the neighborhood, allowing this to come back at the next available meeting with the understanding the county would bear the costs.
We will.
You know, just one block off.
So
Okay.
I really can't argue.
All right. So
One block to the east.
Go ahead. Let
that's okay.
Okay, no,
That happened.
shh, it happens. Yes.
no, it's,
So we need a,
Motion.
Mr. Shaver, we need a motion. Do we need to include the fact that the county will be absorbing the cost for continuance?
Wholeheartedly.
Okay.
yeah, I'll make a motion that
Yes,
we
okay.
have a continuance of the Z 2025 what is it?
10.
10, in order to give us time for proper signage to be located and that all costs would be bared by the county, not the applicant.
Second.
Okay. Any discussion on the motion? All right, all those in favor, please signify by raising your right hand. Okay, all those opposed, motion carries. All right, well, good notice, find on that, and certainly want to make sure everything's done correctly. So that was the only rezoning case we had today, so we'll go ahead and adjourn that meeting, and we'll go into our regular planning board meeting. And so the meeting of the Escambia County Planning Board for November 4th is hereby called to order with 6 members present. We do have a quorum. Do we have proof of publication? Did the publication meet all legal requirements? The chair will entertain a motion to waive the reading of the legal advertisement.
So moved.
A motion and a second. All those in favor, please signify by raising your right hand. All those opposed, okay, motion carries. Planning board meeting minutes for October 7th, 2025 has been provided to the board members. I'll entertain a motion to accept planning board meeting minutes into evidence.
So moved.
Motion and a second.
Second.
All right, all those in favor, please signify by raising your right hand. All those opposed, motion carries. The planning board hearing package for November 4th has been provided to the board members. I'll entertain a motion to accept the planning board hearing package and legal advertisement into evidence. Do I have a motion?
So moved.
Got a motion and a second. All those in favor, please signify by raising your right hand. All those opposed? Okay, motion carries. We have one public hearing today, a small scale map amendment application for consideration, case number SSA 2025-07, which requests the future land use change of 6490 and 6505 Highway 29 North from RC Rural Community to MUU Mixed Use Urban as requested by Meredith Bush, agent for 29 and Molina Road Development LLC, the owner. Staff was notice of the hearing sent to all interested parties. Was notice of the hearing posted on the subject property. And are you good with maps and photographs? Okay, we'll go ahead and have staff present those now.
Okay, this is a SSA 2025-07. This is the location map of the site at Molino and 29. This is the radius map showing the parcel outlined in red as RMU. This is the existing future land use map of rural community. This is the proposed future land use for mixed use urban. This is the aerial photography of the site. This is the public hearing sign that was posted on Highway 29 at the 6490. This is looking at the subject property across Highway 29. Looking south along Highway 29 from the 6490. This is looking northwest next to the subject property. And this is looking at the corner parcel at 6505. Looking at the property between the two subject parcels, just to get a perspective. This is looking west at the intersection of Highway 29 and Molino Road. Looking north from the subject property on 29. This is the public hearing sign that was posted on Molino Road. This is looking at the corner parcel from Molino Road across the street. This is looking onto the site along Molino. It's the back side of the development on Molino. Just another view. And it's another view of the development that on the corner of 6505 Highway 29. And that's the maps and photography.
All right, thank you. Meredith, would you come forward and just state your full name and address for the record again? And then let us know if you received a copy of the hearing package with the findings of fact.
Meredith Bush, 314 South Balin, Suite 108, Pensacola, Florida, 32502, and yes.
Okay, great. Now I'll let you go ahead and proceed with your presentation.
So this is a sort of distinct situation where these properties were previously zoned Gateway Business District and were downzoned during the countywide rezoning in 2015. That action constituted a legal taking of certain property rights by eliminating previously authorized commercial uses and intensities. In response to that unanticipated consequence and to avoid a takings claim, the county implemented a savings clause within the Land Development Code in order for owners in similar situations to restore their development rights. Here we filed the necessary documentation to invoke the savings clause and reestablish the C1, C2, and GBD uses. However, as outlined in the code, to implement those prior uses, the future land use category has to be amended. And so here we're seeking a FLU amendment to mixed use urban, which will go along with the entitlement from the savings clause. The cost of the application is borne by the county, and in this case, the county is supportive of our request. However, I'll walk through the criteria. As far as environmental, we're in flood hazard zone X. Soils, not your fine sandy loam soils. We're not within a wellhead protection area. Traffic, average daily traffic in the vicinity of this project, 17,500 trips on Highway 29, about 2,200 trips on Molino Road. The amendment will not adversely affect capacity of the surrounding roadways. Our packet includes documentation from Molino Utilities indicating that sanitary sewer and water are available to the property. The proposed amendment is not expected to create capacity problems for Molino Utilities. Again, no wetlands on the subject property. It's in the Jacks Branch drainage system basin. Solid waste will be provided by ECUA. The level standard for solid waste disposal, 6 pounds per capita per day, and the Perdido landfill has adequate existing and projected capacity. Parks, recreation, and open space. The proposed amendment will not adversely affect parks, recreation, or open space. As far as schools go, school assignments for this property are Molino Park Elementary, Ernest Gordon Middle School, and Northview High School. Changing to mixed-use urban with a GBD savings clause category is not anticipated to create any capacity issue for the school district. And we've also submitted documentation from the Florida Division of Historical Resources noting that there are no protected historical or cultural references on the subject property. Our application outlines many comprehensive plan provisions with which we are compliant and supportive. And again, this is part of the necessary remedy to that countywide rezoning, which removed the GBD uses. As an aside, although not required by the county, we also voluntarily recorded, or we haven't yet recorded, but prepared, executed, and will record upon adoption a limitation on the property to agree not to implement any of the super heavy industrial uses such as salvage yards, solid waste transfer facilities, materials recovery facilities, recycling facilities, volume reduction plants, concrete or asphalt batch plants, any mineral extraction, paper mills, power plants, chemical plants, refineries, slaughterhouses, etc. So, and I'm happy to take any questions.
All right. Do we have any questions for the applicant? All right, seeing none, we'll let you sit down and we'll turn it over to staff at this time.
So since we don't have any speakers, I can either go through everything, explain the GBD and the savings clause, or I can give you the short version.
Short version.
Short version.
Okay.
All right, I think you.
This is the small scale map amendment. 6.95 plus or minus acres from rural community to mixed use urban, and the sweet and short is that this does meet all the requirements that the state has for small scale map amendment. It is 6.95. It is less than the 50 acres. It isn't in an area of critical concern, and it doesn't. This doesn't require any text change to the comprehensive plan. So it does meet all requirements for a small scale, and staff agrees.
And just briefly, and to add to the side, you know, heavy commercial light industrial, it does incorporate some of the egregious uses, but the client on their own accord agreed to eliminate some of those uses, and we thought that was very, very favorable. So with that, staff is full as an agreement that mixed use urban, because mixed use urban does allow for some type of light industrial uses, but they're going to limit the heavy side. So that's why staff is in full support of this agreement, and because of their willingness to do that, and with the concern that the BCC had raised, we did all of the changing of the zone in the future land use category.
All right. Any questions for staff? Meredith, do you have anything else? All right. And then if not, I'll entertain a motion.
Motion to approve.
Motion to approve in a second. All those in favor, please signify by raising your right hand. All those opposed? All right. Carries. That was all we had today. Is anything from staff before we adjourn for the day?
And this rezone and the one that we're gonna.
All righty. Thanks. We're adjourned.